I never expected that checking my mailbox on a Tuesday morning would lead to a federal lawsuit, but that's exactly what happened when I found the crisp white envelope from the Riverside Oaks Homeowners Association tucked between grocery store flyers and credit card offers. My name is Gregory Gibson, and I had lived in my 3-bedroom ranch house in Riverside Oaks, a planned community outside Charlotte, North Carolina, for 8 years. The neighborhood was nice enough, tree-lined streets with modest homes built in the early 2000s, the kind of place where people waved at each other while mowing their lawns and kids rode bikes until the streetlights came on. The HOA had always been relatively quiet, collecting dues for landscaping the common areas and maintaining the community pool. I paid my fees on time, kept my grass trimmed, and generally stayed out of neighborhood politics. That changed the moment I opened that letter. The document was printed on official HOA letterhead, signed by Karen Caldwell, the HOA president. Karen was exactly what you would picture when someone says HOA president. She was a 48-year-old woman with an asymmetrical blonde haircut that looked like she had specifically requested to speak to the stylist's manager, oversized sunglasses perpetually perched on her head, and an expression that suggested she was constantly disappointed in everyone around her. She drove a white Lexus SUV with a Live Laugh Love bumper sticker, and she took her role as HOA president with the seriousness of a Supreme Court justice. The letter informed me that my voting rights in the HOA had been suspended indefinitely, effective immediately. According to Karen's carefully worded statement, I had violated multiple community guidelines, failed to maintain my property to association standards, and demonstrated a pattern of behavior detrimental to the community's well-being. Therefore, the board had voted unanimously to strip me of my voting privileges until further notice. I read the letter 3 times, standing in my driveway, my coffee growing cold in my other hand. This had to be a mistake. I had not received any warnings, no citations, no notices of violations. My lawn was green and freshly mowed. My house was painted a standard beige that matched every other house on the block. I had not thrown wild parties or left garbage cans at the curb past collection day. What violations was she talking about? I went inside and immediately called the HOA office number listed on the letter. The phone rang 4 times before going to voicemail. Karen's recorded voice informed me that the office was open Tuesdays and Thursdays from 9 to noon and that all inquiries should be submitted in writing. It was 9:30 on a Tuesday morning. I grabbed my keys and drove to the community center where the HOA maintained its small office. The community center was a low brick building near the pool, equipped with a meeting room, a small gym, and the HOA administrative office. I found Karen sitting behind a desk, typing on her laptop. She looked up when I entered, and her expression immediately shifted to what I can only describe as hostile satisfaction. "Gregory," she said, drawing out my name like it tasted unpleasant, "I assume you received our letter." "I did, and I need to understand what this is about. What violations are you referring to? I have not received any notices." Karen folded her hands on the desk in front of her, her acrylic nails clicking against the wood. "The board does not need to provide notice for every minor infraction. We have documented numerous issues with your property over the past 6 months." "What issues? Be specific." She pulled out a manila folder with theatrical precision. "Your mailbox was repainted without architectural approval. The color is not on the approved list." I stared at her. "I repainted my mailbox the exact same color it was before. It is black. Every mailbox in this neighborhood is black. The shade is incorrect. You used oil-based paint instead of latex. That is a violation of Section 12. Subsection 4 of the Community Guidelines. You are telling me you can tell the difference between oil-based and latex paint by looking at my mailbox?" "I can, and I did. Additionally, you have been parking your work vehicle in your driveway overnight, which violates our commercial vehicle restriction." "I drive a Honda Accord. It is not a commercial vehicle. You use it to commute to work. That makes it a commercial vehicle in the board's interpretation." The absurdity of the conversation was making my head hurt. "Karen, that is not what commercial vehicle means, and you know it. Every single person in this neighborhood drives their car to work. By that logic, everyone is violating the rule." "The board has voted, Gregory. Your voting rights are suspended. If you wish to appeal, you can submit a written request to be heard at the next board meeting, which is in 3 months. 3 months? The annual meeting is next week. We are voting on the budget and new board members. Karen's smile was thin and cold. Yes, I'm aware. Unfortunately, you will not be participating in that vote. That was when I understood what was really happening. I'd made the mistake of questioning Karen at the last board meeting, a gathering I had attended for the first time in years because the HOA had proposed raising dues by 30%. When I asked for a detailed breakdown of where the money was going, Karen had responded with vague references to necessary improvements and rising costs. I had pressed the issue, pointing out that the budget documents provided no line-item details, and several other homeowners had joined in, asking similar questions. The meeting had ended with Karen promising to provide more information, which never materialized. Now, a week before the annual meeting where we could vote on the budget and potentially vote her off the board, she had conveniently stripped me of my voting rights. "This is retaliation," I said. "You are punishing me because I asked questions about the budget. I have no idea what you are talking about. The board's decision was based solely on your violations of community standards. Now, if you will excuse me, I have work to do." I left the office before I said something I would regret. Back in my car, I sat in the parking lot and tried to think through my options. I could wait 3 months to appeal, but by then the annual meeting would be over, the budget approved, and Karen would have secured another term as president. I could pay a lawyer to send a threatening letter, but that would take time and money with no guarantee of results. Then I remembered that Marcus, one of my neighbors 3 houses down, was an attorney. I drove straight to his house. Marcus Fernandez was a patent attorney who worked from home most days. He answered the door in jeans and a t-shirt, coffee mug in hand, looking surprised to see me. "Gregory, hey, what's up? I need legal advice, and I will pay your hourly rate. Do you have a few minutes?" His expression shifted to professional interest. "Come in." I sat at his kitchen table and explained the situation, showing him the letter from Karen. Marcus read it carefully, then read it again, his frown deepening. "This is problematic on multiple levels," he said. "First, HOA bylaws typically require notice and an opportunity to cure violations before penalties are imposed. Second, suspending voting rights is a serious action that usually requires specific procedures. Third, this smells like retaliation, which is legally actionable. Do you have a copy of your HOA's governing documents?" "I have them at home. They gave me a packet when I bought the house, but I have not looked at them in years." "Go get them. I want to read through the bylaws and see what procedures they were supposed to follow." I hurried home and dug through my filing cabinet until I found the thick folder labeled HOA Documents. Inside was the declaration of covenants, conditions, and restrictions, the bylaws, and various architectural guidelines. I brought everything back to Marcus. He spent the next hour reading through the documents, occasionally making notes on a legal pad. I sat across from him, drinking coffee and watching the clock tick toward noon. Finally, Marcus looked up. "Okay, this is even worse than I thought. According to your HOA's bylaws, before any member can have their voting rights suspended, they must receive written notice of specific violations, be given 30 days to cure those violations, and if they fail to cure, they must be granted a hearing before the board where they can present a defense. Only after that process can the board vote to impose penalties, and even then, voting rights can only be suspended for failure to pay dues or assessments. Violations of community standards can result in fines, but not loss of voting rights." So they completely ignored their own rules. Not just ignored, they violated your rights under North Carolina law. HOA members have property rights in the association, and those rights cannot be stripped without due process. This is a clear due process violation. "What can I do about it?" Marcus leaned back in his chair. "You can sue, and honestly, I think you should. This is not my area of expertise, but I know someone who specializes in HOA disputes. Her name is Jennifer Wu, and she is tough as nails. If you want, I can reach out to her. Do it. I want to fight this. Just so you know, litigation is expensive and time-consuming. Even if you win, it could take months or years. The annual meeting is next Tuesday. Is there any way to move faster?" Marcus thought for a moment. "We could file for emergency injunctive relief." Essentially, we ask a judge to immediately restore your voting rights pending a full trial. If we can demonstrate that you will suffer irreparable harm by missing the annual meeting vote and that you are likely to succeed on the merits, a judge might grant a temporary restraining order. How fast can we move? If Jennifer is willing to take the case, we could potentially file by the end of the week and get a hearing early next week. But that is aggressive timing. Set it up, whatever it costs, I will pay it. Marcus called Jennifer Wu right then. I listened to his side of the conversation, hearing him explain the situation in legal terminology that went over my head. When he hung up, he was nodding. She wants to meet with you today at 4. She thinks you have a strong case. Jennifer Wu's office was in a professional building in downtown Charlotte, a modern glass tower with a lobby that smelled like expensive cologne and ambition. Her office was on the 14th floor, and she met me in the reception area herself, a woman in her mid-30s wearing a sharp black suit and carrying an intensity that suggested she did not lose often. We sat in her conference room, and I walked her through everything again. She took notes on a tablet, occasionally interrupting to ask pointed questions. Did you ever receive any written notices about violations before this letter? Never. Have you paid all your HOA dues and assessments on time? Every single one. I can provide bank statements. Have you had any personal conflicts with Karen Caldwell prior to the budget meeting? Not really. We were not friends, but we were not enemies either. I barely interacted with her before that meeting. Jennifer nodded, tapping her screen. And you are certain this is retaliation for questioning the budget? I cannot prove it, but the timing is too convenient. I ask questions, she gets embarrassed, and suddenly I lose my voting rights a week before the annual meeting. Okay, here's what I'm thinking. We file an emergency motion for a temporary restraining order and preliminary injunction. We argue that your voting rights are being stripped without due process, in violation of both the HOA's own bylaws and North Carolina law. We argue that you will suffer irreparable harm if you cannot vote in the annual meeting, because once that meeting happens, you cannot get that opportunity back. We ask the court to immediately restore your voting rights and enjoin the HOA from interfering with your participation in the meeting. What are our chances? Honestly, pretty good. The HOA clearly did not follow its own procedures, and courts take due process violations seriously. The question is whether we can get in front of a judge quickly enough. I will start drafting tonight and file first thing Thursday morning. We will request an emergency hearing for Monday. What about costs? My retainer is $5,000. If this turns into full litigation, it could run much higher, but let's start there. If we win, we can ask the court to award attorney fees, which HOA cases often allow. I wrote her a check that afternoon, money I'd been saving for a new roof. As I left her office, I felt something I had not felt since opening Karen's letter: hope. The next few days were a blur of preparation. Jennifer called me repeatedly with questions, asking for documents, bank statements, emails, anything that could support our case. I provided everything she requested, digging through years of records to prove I had been a member in good standing. On Thursday morning, Jennifer filed our emergency motion in Mecklenburg County Superior Court. By Thursday afternoon, the HOA had been served. I was at work, teaching history at a local high school, when my phone started buzzing with text messages from neighbors. "Did you sue the HOA?" one message read. "Karen is losing her mind," said another. "About time someone stood up to her," wrote Mrs. Patterson from across the street. Apparently, Karen had received the court papers and immediately sent an email to the entire neighborhood, claiming I was a disgruntled troublemaker who was wasting association resources with a frivolous lawsuit. She urged everyone to ignore my baseless claims and assured them that the board had acted properly. My phone rang. It was Jennifer. "I see Karen sent out a community-wide email about the lawsuit," she said. "Forward it to me immediately." Why? Because she just made our case stronger. That email could be considered witness intimidation or an attempt to prejudice potential fact witnesses. Plus, it shows a pattern of targeting you specifically. I forwarded the email, and Jennifer added it to our court filings as an exhibit. The court scheduled our emergency hearing for Monday morning at 9, exactly 8 hours before the annual HOA meeting was set to begin. Jennifer warned me that we might not get a ruling in time, but at least the judge would hear our arguments. I barely slept Sunday night. I'd taken the day off from work, and I put on the same suit I wore to parent-teacher conferences and job interviews. Jennifer met me outside the courthouse at 8:30, carrying a leather briefcase and wearing an expression of calm confidence. The HOA hired outside counsel, she told me as we went through security. Firm called Peterson and Associates. They represent a lot of HOAs in the area. Their lawyer's going to argue that this is an internal association matter that courts should not interfere with. Will the judge buy that? Not if I have anything to say about it. The courtroom was smaller than I expected, wood-paneled and formal, with about 20 seats for observers. Karen was already there, sitting with a man in a gray suit who I assumed was the HOA's attorney. She glared at me as I entered, her mouth pressed into a thin line. The bailiff called our case, and we approached the bench. The judge was a woman in her 50s named Judge Patricia Brennan, and she looked at both attorneys with an expression that suggested she did not appreciate having her Monday morning interrupted. "Counsel, I have read your filings," Judge Brennan said. "Ms. Wu, you are asking me to intervene in an HOA's internal governance. That is a significant request. Make your argument." Jennifer stood. "Your Honor, this is not about internal governance. This is about fundamental due process. Mr. Gibson has been stripped of his voting rights without any notice of violations, without any opportunity to cure alleged deficiencies, and without any hearing. The HOA's own bylaws require all of those procedural protections before voting rights can be suspended. Additionally, under North Carolina law, HOA members have property rights in the association that cannot be taken without due process. The HOA has violated both its own rules and state law." The HOA's attorney, a man named Robert Peterson, stood to respond. "Your Honor, HOA boards have broad discretion to enforce community standards. The board documented violations and made a determination. The plaintiff has an internal appeal process available. This court should not micromanage HOA decision-making." "Did the HOA follow its own bylaws regarding notice and hearing procedures?" Judge Brennan asked. Peterson hesitated. The board determined that the violations were sufficiently serious to warrant immediate action. "That is not what I asked. Did the HOA follow the procedures outlined in its own bylaws? Yes or no?" The board exercised its discretion to yes or no counsel. "No, Your Honor, but and does the HOA's bylaws provide for suspension of voting rights for community standard violations?" Another pause. The board interpreted its powers broadly to, again, counsel, yes or no. The bylaws specifically allow suspension only for non-payment of dues. Judge Brennan looked down at the papers in front of her, then looked up at Peterson with an expression of clear annoyance. "So you are telling me that your client ignored its own procedural requirements and imposed a penalty that its own governing documents do not authorize, and you want me to let that stand?" "The internal appeal process takes 3 months according to your own bylaws, by which point the annual meeting will be over and the vote will be lost. That is not an adequate remedy for a due process violation." Judge Brennan turned to Jennifer. "Ms. Wu, what exactly are you asking for?" "We are asking for a temporary restraining order immediately restoring Mr. Gibson's voting rights and enjoining the HOA from interfering with his participation in tonight's annual meeting. We will also be filing a full complaint seeking damages, but the immediate issue is preserving his right to vote." "Your Honor, the annual meeting is this evening," Peterson interjected. "Even if the court were to grant this relief, which we strongly oppose, there is no time to, there is plenty of time. Counsel." It is 9:45 in the morning. Judge Brennan picked up her pen. "I am granting the plaintiff's motion. Mr. Gibson's voting rights are immediately restored. The HOA is enjoined from preventing or interfering with his participation in tonight's meeting. The HOA is further ordered to send notice to all members no later than 3 o'clock this afternoon, informing them that Mr. Gibson's voting rights have been restored by court order. We will schedule a hearing on the preliminary injunction for 2 weeks from today. In the meantime, this TRO remains in effect." Karen made a noise that sounded like a strangled gasp. Peterson tried to object, but Judge Brennan was already standing. "Anything else, counsel?" "No, Your Honor," Jennifer said, failing to suppress a slight smile. Then we are adjourned. Ms. Wu, prepare the order and have it to my clerk by noon. I walked out of the courthouse in a daze. Jennifer was shaking my hand and saying something about next steps, but all I could think about was the look on Karen's face when the judge issued the ruling. "Gregory, are you listening?" Jennifer asked. "Sorry, yes, what do you need from me?" "Nothing right now. Go home, relax, and be at that meeting tonight. Document everything. Record it if you can. And whatever Karen does, do not engage with her. Let her dig her own hole." I went home and tried to focus on grading papers, but my mind kept wandering. At 3:15, my email dinged with a message from the HOA. It was curt, just 2 sentences. "Please be advised that per court order, Gregory Gibson's voting rights have been restored. He is permitted to attend and vote at tonight's annual meeting." At 6:30 that evening, I walked into the community center. The meeting room was packed, every chair filled and people standing along the walls. Apparently, word had spread about the lawsuit, and everyone wanted to see what would happen. Karen stood at the front of the room, flanked by the other board members, Todd Westbrook, the vice president, Sarah Miller, the treasurer, and David Chen, the secretary. Karen's face was rigid. Her jaw clenched so tight I thought her teeth might crack. I took a seat in the 3rd row, directly in her line of sight. Several neighbors patted me on the shoulder or gave me thumbs up as I passed. Karen called the meeting to order at 7 sharp. Her voice was strained, higher pitched than usual. "Welcome to the annual homeowners meeting. We have a full agenda tonight, so let us begin with the approval of last year's minutes." The minutes were approved without discussion. Then came the treasurer's report. Sarah Miller, a nervous woman in her 60s, stood and read from a prepared statement about the association's finances. The numbers were vague, rounded to the nearest thousand with no real detail. When she finished, I raised my hand. Karen's eyes fixed on me like lasers. "Yes, Gregory." "I would like to see a detailed financial report showing line item expenses for the past year and the proposed budget for next year. The bylaws state that members are entitled to review financial records. We have provided a summary. I am requesting the detailed records. This is not the appropriate forum for. Actually, the bylaws state that financial records must be available for inspection at the annual meeting. I am making that request now." The room had gone silent. Every eye was on Karen and me. "Fine," she said through gritted teeth. "Sarah, provide Mr. Gibson with the detailed records." Sarah looked panicked. "I do not have them here." "Then we will table the budget vote until those records are provided," I said. "We cannot table the budget vote," Karen snapped. "It must be approved tonight." "Then provide the records," I replied calmly. Jennifer had coached me on this. Stay calm, be reasonable, follow the rules. Make Karen be the unreasonable one. Karen conferred with the other board members in urgent whispers. Finally, she turned back to the room. "We will take a 15-minute recess while the treasurer retrieves the financial documents." The room erupted in conversation as soon as Karen stepped out. Several neighbors approached me. "I am so glad you are doing this," Mrs. Patterson said. "Karen has been out of control for years. She fined us $200 because our Christmas lights were the wrong shade of white. She threatened to put a lien on my house because my lawn had clover in it," added Mr. Thompson. "Clover, like that is somehow destroying property values." More stories came out. Karen had apparently been running the HOA like her personal fiefdom, issuing arbitrary fines, playing favorites with her friends, and spending association money on things that only benefited her side of the neighborhood. The pool furniture near her house got replaced every 2 years. The playground near mine had not been updated in a decade. When Karen returned, she looked even more tense. Sarah Miller carried a laptop and nervously set it up to project onto the wall. What appeared on screen was damning. The HOA had spent $40,000 on landscaping improvements, but when I cross-referenced the dates with my memory, those improvements seemed to have only happened on Karen Street. There was a $15,000 expense labeled legal consultation that had no supporting documentation. The HOA had also paid $5,000 for a community appreciation event that I had never heard of. "What was the community appreciation event?" I asked. Sarah looked at Karen, who answered. "We hosted a cocktail party for longtime residents." "How many people attended?" 20. I did some quick math. So we spent $250 per person on a party? Where was it held? Karen's face was turning red. That is not relevant. It is absolutely relevant. That is our money you were spending. Where was the party? It was catered at my home. The room exploded. People were shouting questions, demanding to know why Karen had spent $5,000 of HOA money on a party at her own house. Karen tried to bang her gavel and restore order, but the damage was done. I moved to remove the current board and hold emergency elections, someone called out. Seconded, 3 people said simultaneously. Karen looked like she might cry or explode. I could not tell which. You cannot just remove the board. Actually, we can, I said, pulling out a copy of the bylaws that Jennifer had marked up for me. Section 8, subsection 3. The membership may remove any board member with or without cause by a 2/3 vote at any duly noticed meeting. This is a coup, Karen said, her voice shaking. No, this is democracy, I replied. We voted. Out of the 97 members present or represented by proxy, 74 voted to remove the entire board. Karen, Todd, Sarah, and David were out. We then held emergency elections. Mrs. Patterson was elected president. Mr. Thompson became vice president. A retired accountant named Linda Harris became treasurer, and a former teacher named Michael Brooks became secretary. I declined nomination, saying I had done enough. The new board's first action was to vote to hire an independent auditor to review the HOA's finances for the past 3 years. Their second action was to reduce the proposed dues increase from 30% to 5%. Their third action was to formally apologize to me for the illegal suspension of my voting rights. I left the meeting that night feeling vindicated, but Jennifer warned me that we were not done. You won the battle, but we still need to finish the case, she told me when I called her that night. We are still seeking damages for what they did to you. Is it worth pursuing? Absolutely. They violated your rights. There should be consequences. Over the next 3 months, Jennifer and I built our case. The new HOA board cooperated fully, providing documents and even testifying on my behalf. The independent audit revealed that Karen had spent over $80,000 of HOA money on expenses that primarily benefited her and her friends. Some of it was technically legal, but ethically questionable. Other expenses appeared to be outright fraud. The new board reported their findings to the district attorney's office. Karen was ultimately charged with embezzlement and misuse of funds. She took a plea deal that included probation, restitution, and community service. Meanwhile, our civil case proceeded. The HOA's insurance company got involved once they realized the board had acted outside its authority. They wanted to settle. We went to mediation in August, 6 months after Karen had sent that letter stripping my voting rights. The insurance company offered $20,000 to settle all claims. Jennifer advised me that if we went to trial, we might get more, but there was always risk. What do you think? I asked her. I think $20,000 is a reasonable number. You lost about 10 hours of work dealing with this, suffered emotional distress, and had to pay me $5,000 in legal fees that are not fully covered by their offer. But more importantly, you made your point. You fought back, you won, and you changed the HOA for the better. Sometimes that is worth more than money. I thought about it for about 30 seconds. Let us settle. We reached a final agreement in September. The HOA paid me $25,000 in damages and agreed to pay Jennifer's legal fees separately, which totaled another $18,000. The settlement also required the HOA to amend its bylaws to add stronger due process protections and to provide annual financial transparency reports to all members. When I received the settlement check, I used part of it to replace my roof and donated $5,000 to a local legal aid organization that helps people fight HOA abuse. The rest went into savings. Karen moved out of Riverside Oaks that fall. Rumor had it she relocated to South Carolina to be near her sister. I never saw her again. The new board transformed the neighborhood. They repaired the playground near my house, repaved several streets that had been neglected, and organized actual community events that people wanted to attend. Mrs. Patterson turned out to be an excellent president, running meetings efficiently and treating everyone fairly. Life returned to normal, or at least a new normal. I still went to work every day, taught my classes, graded papers, and mowed my lawn on Saturdays. But something had changed. Other neighbors started coming to me when they had HOA questions or concerns, treating me like some kind of expert. I was not, but I had learned a lot through the process. The preliminary injunction hearing that Judge Brennan had scheduled never actually happened because we settled before then. But Jennifer told me later that the judge had been prepared to not only continue the restraining order, but to impose sanctions on the old board for their conduct. Judge Brennan does not like HOAs that abuse their power, Jennifer explained. She's been reversed a few times by the appellate court for being too harsh on them, but she does not care. She thinks HOAs are miniature tyrannies that need to be kept in check. I could not argue with that assessment. About a year after everything started, I was leaving for work one morning when a new neighbor moved into the house where Karen used to live. He was a young guy, maybe 30, unloading boxes from a truck. I walked over to introduce myself. "Welcome to the neighborhood," I said, extending my hand. "I am Gregory Gibson, 3 houses down." "Thanks, I am Nathan," he said, shaking my hand. "This seems like a nice area." "It is. The HOA is pretty reasonable, at least now. Just pay your dues on time and do not paint your mailbox without approval." I paused. "Actually, even that is probably fine now," Nathan laughed. "Good to know. I heard there was some drama with the previous owners." "You could say that, but it worked out in the end." As I walked back to my car, I thought about how a simple letter in my mailbox had led to all of this. A lawsuit, a settlement, criminal charges, and a complete transformation of how the HOA operated. It had been stressful and expensive and time-consuming, but it had also been necessary. Too many people let HOAs push them around because fighting back seems too hard. They pay the unjust fines, they accept the arbitrary rules, they let petty tyrants like Karen run their neighborhoods like personal kingdoms. I almost did the same thing. If Marcus had not been my neighbor, if Jennifer had not been willing to take the case on short notice, if Judge Brennan had not seen through the HOA's arguments, it all could have turned out differently. But it did not. I fought back, and I won. The legal principle was simple. Even HOAs have to follow the law. They have to follow their own bylaws. They have to provide due process. And when they do not, courts will step in. My case became a small bit of local legal legend. Jennifer told me she had used it as an example when presenting at a conference about HOA law. Other attorneys in the area had cited Judge Brennan's TRO order in their own cases. The local newspaper had written an article about it, though they had not used my name at my request. The most satisfying moment came about 18 months after everything started. I was at the community pool on a summer Saturday, watching some neighborhood kids play Marco Polo, when Mrs. Patterson sat down next to me. "I wanted to thank you again," she said, "for everything you did. You have thanked me plenty of times." "I know, but I mean it. This neighborhood is so much better now. People actually want to come to board meetings. We have reasonable rules that make sense, and nobody is afraid of getting a fine for some made-up violation. You are the one who made that happen. You are a great president. Only because you created the opportunity. If you had not stood up to Karen, she would still be in charge, still spending our money on parties at her house, still making everyone miserable." I shrugged, uncomfortable with the praise. I just did not want to lose my vote. "You did more than that. You showed people that they do not have to accept abuse from an HOA. They can fight back." She was right, though I had not thought about it that way at the time. I had been focused on my own situation, my own rights, my own vote. But the ripple effects had been much larger. Other people in the neighborhood had told me about their own HOA horror stories from before my lawsuit. One couple had been fined repeatedly for having a vegetable garden in their backyard, which Karen claimed violated an aesthetic standard, even though nobody could see it from the street. A single mom had been threatened with a lien because her teenage son had left a basketball hoop in the driveway overnight. An elderly man had been cited for having decorative rocks instead of mulch in his flower beds. All of those citations and fines had been rescinded by the new board. The rules were still enforced, but reasonably, and with actual notice and opportunity to fix problems. I thought about that letter from Karen often, the crisp white envelope that had started everything. At the time, it had felt like an attack, a betrayal, an injustice that needed to be corrected. Looking back now, it had been an opportunity to stand up for myself, to learn about my rights, to make a difference in my community. Would I do it again? Absolutely. Would I recommend others do the same? That was a harder question. Litigation is brutal. It is expensive even when you win. It is stressful, consuming your thoughts at odd hours and making you second-guess every decision. It is uncertain, with no guarantees of success even when you are clearly in the right. And it takes time away from work, family, and everything else that matters. But sometimes it is necessary. Sometimes standing up to bullies and tyrants and petty dictators is the only option. Sometimes the law is the only tool that works. Jennifer and I stayed in touch after the case ended. She would occasionally send me news articles about other HOA disputes, usually with a note like, "Makes your case look tame." I learned that HOA litigation was shockingly common, with thousands of cases filed every year across the country. Most of them settled. Many of them involved situations just as absurd as mine, if not more so. There was the HOA in Florida that tried to ban owners from parking in their own driveways. The HOA in Texas that fined a military family for displaying an American flag. The HOA in Arizona that demanded a homeowner remove solar panels that were saving him hundreds of dollars a month on electricity. The HOA in Colorado that tried to foreclose on a house because the owner owed $17 in late fees. The stories were endless and depressing and infuriating, but they also showed that people were fighting back. Courts were pushing back against HOA overreach. State legislatures were passing laws to protect homeowners from the worst abuses. Progress was slow, but it was happening. As for me, I settled back into my quiet life. I taught my history classes, helped coach the school's academic bowl team, and dated occasionally without much success. I still lived in my house in Riverside Oaks, still mowed my lawn on Saturdays, still waved at neighbors when I checked my mail. But I also paid attention to what the HOA was doing. I read the meeting minutes online, reviewed the annual budget, and attended the annual meeting every year. I never ran for the board because I liked my privacy too much, but I stayed informed and spoke up when something seemed wrong. Other homeowners did the same. The lawsuit had awakened something in the neighborhood, a sense that we had a say in how things were run, that the HOA worked for us rather than the other way around. Meetings became more democratic, more transparent, more responsive to what people actually wanted. It was not perfect. There were still disputes about rules and fines and who was responsible for maintaining what. But the atmosphere was different. The fear was gone. The sense that Karen might show up with a citation for some microscopic violation had evaporated. The HOA became what it was supposed to be, a democratic organization managing shared resources for the benefit of everyone. Years later, I would occasionally get emails from strangers who had found my name connected to the case and wanted advice. People fighting their own HOAs, facing their own arbitrary rules and power-hungry board members. I always responded the same way. Document everything, know your rights, find a good lawyer, and do not back down if you are right. Some of them took my advice and fought. Others decided it was not worth it and moved or paid the fines or gave up. I understood both choices. Not everyone has the resources or the energy or the support system to wage a legal battle. Sometimes survival means choosing your battles carefully, but for those who did fight, who stood up to their HOAs and demanded their rights, I cheered them on. Every small victory against HOA tyranny was a win for all homeowners. Every court decision enforcing due process and limiting HOA power made life better for everyone trapped under those rules. The settlement money I received was nice, but it was never really about the money. It was about the principle. It was about standing up and saying, "No, you cannot do this to me." It was about using the legal system the way it was meant to be used, to protect individual rights against institutional power. Karen had tried to silence me, to strip away my voice in my own community. She had failed. The court had restored my rights and made the HOA pay for violating them. Justice had been served, not perfectly, but adequately. And in the end, that was enough. I still live in Riverside Oaks. My mailbox is still black, though I have not repainted it, and probably never will just on principle. My Honda Accord still sits in my driveway every night. My lawn is green and mostly weed-free, though I stopped stressing about the occasional clover. The neighborhood is quieter now, in a good way. There is less drama, less conflict, less fear. The HOA functions smoothly, maintaining property values without making anyone miserable. Mrs. Patterson eventually stepped down as president after 3 successful terms and was replaced by another reasonable person who continued her approach. Karen's house sold twice more over the years. The current owners are a nice family with 2 kids who play basketball in the driveway without anyone threatening to find them. Sometimes I see the basketball hoop sitting out overnight, and I smile, remembering when that would have been a violation worthy of board action. The community center displays a plaque now, installed by the board a few years ago, commemorating the governance reforms of 2026. It does not mention my name or the lawsuit, just notes that the HOA adopted new procedures to ensure fairness and transparency. I know what it really means, though. It means people fought back and won. It means tyranny was challenged and defeated. It means one person standing up for their rights made a difference for everyone. On lazy Sunday mornings, I sometimes sit on my porch with coffee and the newspaper, watching the neighborhood come to life. Kids ride bikes, people walk dogs, neighbors chat across property lines. It is peaceful and ordinary and exactly what suburban life should be. And when I check my mailbox and see nothing but bills and advertisements and the occasional neighborhood newsletter, I am grateful. Grateful that no crisp white envelope awaits with another attempt to strip my rights. Grateful that the HOA has become boring in the best possible way. Grateful that I fought back when it mattered. The legal system worked, justice was served, rights were restored, and a small corner of suburban America became a little bit more democratic because one person refused to back down. That is the story of how my HOA stripped my voting rights without due process and how the court restored them and added damages. It is a story about standing up to bullies, fighting for your rights, and refusing to accept injustice just because fighting back is hard. It is a story I am proud to tell, even if I never wanted to live through it in the first place. And if you ever find yourself in a similar situation, facing an HOA that has overstepped its authority and violated your rights, I hope my story gives you courage. Because you can fight back. You can win. And sometimes the act of fighting is just as important as the victory itself.